let's look into briefly how other countries have structured their exhaustion. Most countries, including the United States, have national exhaustion enshrined within patent laws because they want to guard patent laws very strongly than other kinds of rights. So although there is a first sale, the first sale is territorial and hence national exhaustion kicks in. However, in one of the decisions called Merck versus Steffer, decided by the European Court of Justice way back in the 1980s, it says that wherever there is a first sale in a country where the patentee has taken the risk, in spite of the fact that he does not own a valid patent there, has put the product in the market, the exportation of such products outside a particular country and importation into the other country would not constitute an infringement of the patent right in the country in which it is imported. Practically means that a situation similar to India, where exhaustion would kick off by virtue of the fact that a person, although there is no intellectual property, and if he puts the product into market, would not be entitled to raise a contention that his rights have been infringed. This Merck versus Steffer decision is kind of unique because the court's argument was A, that there should be free trade within the European communities, and second B, that since the patent owner himself took the risk of putting the product in the market, wherein there was no valid patent that was granted, the rights would get exhausted by virtue of the first sale by himself. Now, if you apply this particular decision in the context of India, Section 107, Clause A, Clause B seems, although contentious with reference to TRIPS agreement, but there are certain other practices followed in comparative jurisdictions which are equally contentious. However, it may be noted that this Merck versus Steffer decision was one in its case, and it has not been followed largely in other parts of the world. Moving on to the exhaustion regime of copyrights in India, one of the important decisions in relation to exhaustion is the decision in Penguin Books. Here the plaintiff was a leading publisher of books, and he entered into several agreements with the copyright owners, which the plaintiff claimed assigned rights over his works exclusively, and in relation to printing and publishing of these works to the plaintiff in India. The plaintiff alleged that the defendants imported the books from those countries and were offering for sale in India. Hence, defendant were infringing the copyright owned by the plaintiffs. The defendant opposed this kind of argument by the plaintiff on the ground that there was a consent decree in the United States where they were allowed to sell the product lawfully. However, the division bench felt that the consent order was not a material fact and it was confined in its operation to the territory of United States. The plaintiff could not be bound by the decree, and hence the rights under Indian law were to be strictly construed. So coming to the Copyright Act of 1957, the courts interpreted Section 51 in a very unique fashion to mean that any importation of infringing copy would amount to infringement unless it was for the importer's own use. Now, therefore, an action which did not involve the copyright owner's consent and importation of such books without the consent or without the permission of the copyright holders and without his exclusive license would mean infringement. Now, this particular decision raised many issues, and the interpretation of specifically Section 51 Clause B, Clause 4 read with provision 2M meant that in relation to copyright, India followed a national exhaustion regime. However, this particular Section 14 was amended in 1994 post the Penguin Books decision to include the first sale doctrine, and some have argued that by virtue of Section 14 being amended and inclusion of the first sale doctrine, the first sale doctrine is not just territorial but it is international exhaustion. Unfortunately, the courts have not understood the import of this amendment, and in Eurokids International versus India Books Distributors Limited, a case decided in 2005 by the Bombay High Court, the court has come to a conclusion by relying again on Penguin Books that Section 4A2 provides for a fair use for a first sale doctrine. However, it's limited to national exhaustion when read along with the meaning of infringing copy in section 52b4. Interestingly, the courts have gone ahead in India to provide parallel exports as such, and this concept is very unique because most countries allow exportation of products without the consent of the patent holder, because anyway it does not infringe the rights territorially. However, in this case of John Wiley and Sons versus Prabhat Chander Kumar Jain, a case decided by the Delhi High Court in 2010, the plaintiff was a leading publisher of academic scientific journals which had a wide circulation, and he came out with a low priced edition of the book in Indian market. These editions were meant for sale only in India and South Asian nations. However, the defendant exported those books outside the country. Now, the plaintiff alleged that copyright infringement against defendant who was exporting these low priced editions, and granting an injunction in favor of the plaintiff, the Delhi High Court said that the right of the owner of the copyright to issue copies of the work to the public would not be circumcised by any territorial limitation. Thus, the owner of the copyright would have the worldwide right to issue such copies of the work. Now, this primarily means that the court has completely got this particular proposition in an erroneous fashion, because section 14 clearly says that copy is not already in circulation. It means what you do with the copies in terms of either selling them within India or outside India is left to the buyer and not to the IP holder. Now, this particular view is kind of per incurium when you consider the actual meaning of an import of section 14a clause 2. Owing to the fact that many court decisions in India have interpreted section 14 to mean first sale as applied to Indian territory and hence national exhaustion, section 2m, which defines infringing copy, was sought to be amended by specifically allowing for international exhaustion. However, this amendment was defeated in 2012 owing to active lobbying by publishers, wherein finally the Ministry of HRD came to a conclusion that post the amendment, a report on what kind of regime, copyright regime, exhaustion regime should follow would be commissioned, and NACER, that is National Council for Applied Economic Research, was commissioned this report, and they have come to a conclusion that in the interest of consumers and benefits that are due to consumers by virtue of international exhaustion, it would be important that countries follow international exhaustion, and they have done a fantastic empirical study which is available on the website of the Ministry of HRD. In relation to exhaustion of trademarks in India, the provisions are quite unique in the sense that it has been highly contested in court decisions, and currently a case regarding whether India follows international exhaustion or national exhaustion in relation to trademark is pending in the Supreme Court. Now, if you look into section 30 clause 3 of the Trademarks Act, it reads that where the goods bearing a registered trademark are lawfully acquired by a person, the sale of goods in the market or otherwise dealing in those goods by the person or by a person claiming under or through him is not infringement of trade by reason only of a, that the registered trademark may have been assigned by registered proprietor to some other person after the acquisition of those goods, or the goods having been put on the market under the registered trademark may mark by the proprietor with his consent. The only exception to this provision is section 4, which reads that subsection 3 shall not apply where there exists legitimate reasons for the proprietor to oppose further dealings in goods, in particular where the condition of goods has been changed or impaired after they have been put on the market. Now, in Samsung decision, which was decided initially by the single bench, Samsung Electronics versus Kapil Wadhwa 2012 decision, the single bench came to a conclusion that the regime in India under section 33 read with section 29, they came to a conclusion that trademark regime was national in character, exhaustion was national in character. However, this was immediately challenged in the division bench, and the division bench, looking into the objects and reasons of the act and the general principles of interpretation, have come to a conclusion that India follows international exhaustion regime for trademark. Primarily, the reliance placed by the division bench was on the objectives of the act, which clearly state that the reason for amendment was to specifically incorporate an international exhaustion regime in India, and they have made certain remarks over the single bench's decision, where the interpretation and the interpretative techniques that were used by the single bench in relation to section 33 of the act were not upheld by the division bench. However, as mentioned, this case has now gone to the Supreme Court, and we are expecting the Supreme Court to rule on the kind of regime of exhaustion that India follows in relation to trademarks.